the rights of fathers in the spotlight. The Constitutional Court ruling that unmarried biological fathers should be allowed to access full parental responsibilities in the lives of their children. This as changes to the Children's Amendment Bill are implemented. To discuss, we're joined by Lithalethemba Stwayi, who is an attorney at the Centre for Child Law. Thank you very much for joining us. You support this move. Tell us why.
So from the article that spoke about the bill, it's slightly misleading, just in the point where the Children's Act, when it was enacted in 2005, already had the section for unmarried fathers and acquiring access to their kids. So what this bill is actually doing, it's amending the entire Children's Act, but also that section that deals with unmarried fathers. So before it said that a person can go to the court to get his parental responsibilities and rights confirmed if they were in a relationship with the mother before the child was born, or they were living with the mother before the child was born, or right after the child was born, if they were assisting with contributing to the upbringing of the child or maintaining the child. And so this bill is now trying to simplify that, saying that you don't have to go to the children's court to have your rights confirmed, but you can go to the family advocate's office just to make it cheaper for the fathers to get that court order that actually states that.
Okay, so fathers always had this right, or they've had it for a while, but this makes it more easy to give effect to that when the children's bill is passed into law.
Yes, so that section has always been in the Children's Act in order for fathers who need to go to court, maybe if the mother is not giving them access already to the child, because not everybody goes to court. There are people who have been co-parenting who have never been to court, and the father has been exercising his parental responsibilities and rights. But in the event where a mother is stifling that and does not want the father to have contact or care of the child, then that father can go to a court to confirm his rights, and then there will be a parenting plan drawn up. And then if the mom does not follow the parenting plan, then there'll be repercussions.
Yeah. How have things changed over time for men? It was often said in the past that the courts were biased in a sense towards mothers. They were seen as maternal, nurturing, the natural caregivers. Would you say now mothers and fathers are almost on equal rights, or do have equal rights?
So mothers and fathers do have equal rights according to the Children's Act. But in South Africa, we're a country where children are not only raised by their mothers, they're raised by aunts, they're raised by grandparents. Some children are actually raised by their fathers. And I think the Concourt case is the Naki judgment where the father has been raising the child. And unfortunately, because when you go and register on the birth certificate and you're unmarried, automatically the child gets the surname of the mother. So because he's raising the child, anytime he needs to practice any agency with regard to the child, consenting to the child getting an ID or a passport, or consenting to school, they would state where is the mother, because you and this child, there's nothing that actually says you're the father of this child. There's nothing that you don't share a surname, you don't have a birth certificate with your information on it. The birth certificate has the mother's information. So this now helps have like a legal document that you can take to wherever you need to take it to even show that you are actually the father of the child.
Yeah. Does the child still take generally the mother's surname though?
So as the law stands with the Births and Death Registrations Act that governs home affairs, it says if a child is born to unmarried parents, the child gets the surname of the mother, unless the father in writing consents to have his information inserted onto the birth certificate and elects that the child gets his surname. So at the moment, as a default, it's still the child gets the mother's surname.
Yeah. Finally, tell us about the disputes that could arise. People are grappling with this. Say the mother has custody, but the father sees the child, and the mother wants to move to a different province. She gets a job. Then what happens?
So in such cases, if the father basically does not agree or says, no, you'll be stifling my rights to have access to the child, then as the law already says, but as this bill now proposes in full, it says that you must go for mediation to the family advocate's office. And this happens quite often. So one parent has to move to another province, and the access that the father had, or the contact, maybe he was seeing the child every weekend, the other parent probably won't be stopped from leaving, but it's just to iron out those issues that I'm not leaving for no reason. I'm leaving for a job that I have. We will still maintain contact. The child will still be able to speak to the father. It's just going to be slightly more difficult because we'll be in different provinces, but I will still allow him to access the child. He can see the child on school holidays, just like they were alternating. It's just now that there's more distance. So in those cases, usually the parent will still have to, would still be able to leave, but it's just to curb situations where it was already tumultuous when the father had to go to court to get his rights confirmed, and then the mother leaves without actually notifying him. So in those cases where you go to the house and the child is no longer there, there's nobody there. So it's to just kind of simplify that whole process.
All right, thank you for that explanation tonight. Lithalethemba Stwayi, attorney at the Centre for Child Law.